So class, today we have to start with the Memorandum of Association and Article of Association of the Company Act. So right now we have just discussed about what exactly the meaning of company and the key features of company. So let's start with the Memorandum of Association and Article of Association. So guys, if we talk about the important document, okay, so the important document of your partnership is partnership deed. And if we talk about the company, so for company, memorandum of association and article of association is the most important document. So these are the basic documents required by company prior to its incorporation and has to be registered with the registrar of the company. So basically we can say that the memorandum and article of association is one of the most important, it is one of the most important document that every company have to just file with the registrar, okay, because registration is also important, so that's why this is also much important, okay. So the MOA, now if we talk about the basic difference between MOA and article of association, so memorandum of association give the basic detail of the company and its objective and the most important document for a company. So we can say that, see, Company Act is there, right? Company Act, Memorandum of Association is there, and then Article of Association. It means Article of Association have to follow the rules and regulations of MOA and AOA, and MOA have to follow the rules and regulations of the company. So this is the hierarchy that you people have to follow, okay. AOA, on the other hand, which is the second most important document for a company, consists a set of rules, regulations, bylaws made by a company for internal management and carrying out object of the company embodied in the memorandum of association. So basically we can say that AOA, let's talk about the internal management of the company. That is very much important. So if anyone say that what is the basic difference between MOA and AOA, so MOA is the charter of a company and AOA is talk about the internal rules and regulations of the company. So that is the basic thing, okay. Now both MOA and AOA has to be normally filed with the ROC, that is the registrar of company, before registration of the company. And once registered, this is very much important, once both document register, so it's bind the company to absorb all the provision of MOA and article of association. Very much important. Okay, so this is important for the examination point of view also. Okay, now let's start with the question. Suppose class, if there is a conflict, okay, if there is a conflict, right, between the memorandum of association and article of association, the article of association will prevail. Tell me, who will prevail? Which document will prevail, class? So in the case of conflict between MOA and AOA, always remember the memorandum of association will prevail. So that's why this is the false statement. One of the clause contained in MOA is the objective clause. So if you talk about the memorandum of association, so we can say name clause is important, capital clause is important, liability clause is important, association or subscription clause is important, okay. So name, capital, liability, association, object, and the registered clause. So these are the 6 clause. It's a 1, this is 2, this is 3, this is 4, this is 5, this is 6. So these are the 6 clause that every company have to file. That is important, okay. So this is the true statement. This is the true statement. False, this is true, okay. Now the memorandum and article of a company once registered, it's bind the firm. The memorandum and article of a company, one registered, it will bind the firm. So class, this is absolutely the true statement. So this segment is, that is finished. That is important. Is that okay? Now class, there are three doctrines. So doctrine is basically the rules. What is doctrine? Doctrine is basically the rules. So in your this Company Act, we have a three rules: ultra vires, constructive notice, and indoor management. So three things are there. So what is ultra vires? So ultra vires is basically, suppose whatever that is written in the MOA, every company have to follow that MOA. No company can do that act which is beyond the MOA. So this is your MOA. No company can do the act which is beyond MOA. Is that okay? So doctrine of ultra vires lay down that the company cannot carry on the object not permitted by its memorandum of association. So this is your ultra vires. Okay. So basically it means beyond the power. What is this? It means beyond the power. This is called ultra vires. A very simple definition. Okay, this is ultra vires. Now class, doctrine of constructive notice. So suppose X person want to invest in a Y company. So Y company will give the memorandum and article of association. Now class, what will happen? Now this X person, if we say X person, okay, he have to read all the terms and rules and regulations of these documents. Suppose if X person have not read the 10 rules of MOA, in that case, this is not the fault of company, but this is the fault of X. So once the document is given to the outsider or investor, so guys, it is assumed to have read the memorandum of association and article of association. So every outsider is assumed. So constructive notice basically protect the what? Company. It protect the company. This is constructive notice. And indoor management basically protect the outsider. Okay, it protect the outsider. Suppose X person is there, same example. Okay, X is there, Y is there. So Y want to give, X want to invest in a company. So Y have given MO and AOA to the X. In that case now, after giving, the Y company have changes something in the article of association, but that changes he have not informed to the outsider. So in that case, the company will be liable, not this one. So that's why, as you can see here, indoor management protect the outsider, constructive notice protect the company. That is important. Is that okay? And ultra vires, the one word that is beyond the power. This is important. Any doubt, class? That is clear to all of you? Okay. Done, class? So now let's do the question. Doctrine of ultra vires lay down that every outsider okay, is assumed to have read the Memorandum of Association and Article of Association. Tell me, class. Important. So right now, class, we have discussed. Right now we have discussed, so that's why this is not the right answer. This is the false statement. This is called constructive notice. Okay. Doctrine of okay. So definition there. Doctrine of constructive notice state that the outsider are not required to see the compliance of internal regulations of the company. This is your indoor management definition, and this is also the false statement. Indoor management lay down that the company cannot carry on the object not permitted by MOA. So this is ultra vires, and this is the false statement. So I have just written the exact statement that is given in each point. So please see that points. Done? So I hope so. That is clear to all of you. Now let's start with the thing. Member. So member of a company has been defined in section 2 clause 55 of the Company Act 2013. So class, any person competent to contract can be the member of a company. Exactly. Any person, guys. Okay. Competent to contract. So competent to contract is basically that is plus 18, sound mind, and not disqualified by the law. This is called this. Okay, so there are various mode by which a person entity can acquire membership of a company. Also various circumstances where membership in a company will be ceased. So there is a so many points in which the membership can be seized and so many points in which the membership can be acquired. So this is important. Done? Now, every company is required by the statute to keep an updated register of member, debenture holder containing the certain minimum information as specified. The register are to be kept in the register office of company and open to inspections by the general public. Company confer certain rights to the members such as statutory rights, documentary rights, property rights. Statutory right that is written in a particular act, documentary that is written in MOA and EOA, and this is the journal rights which is given to the member of a company. That is important. Done? So this is important. Done? Now, a minor can be the member of private company but not of public company. This is right and false. A minor can be the member of private company but not for the public company. This is false statement because minor cannot be the member of a company. Minor can inspect the register of member can be inspect the register of members. That is true and false. So this is class absolutely true. A company limited by share, the member is liable to pay full nominal value of the share and liability of the member ends there. Tell me. So class, if a company is limited by share, so the members liable to pay only the this one. So this is the false statement. A company is required to keep its foreign register in India only. a company is required to keep its foreign register in India only. That is the false statement because they have to kept in the foreign also. Okay, so this is important. Next, now class about the prospectus. A public company has to issue a prospectus before raising fund from the public. Okay, company, the promoters and the directors of the company certain liabilities for any wrongful statement that is included in the prospectus. So the liability can be civil and the criminal liability. Is that okay? The liability can be civil and the criminal. Done? Okay. Now, there is a no remedy available for misstatement in prospectus by the director. No remedy available. That is the false statement because we have a remedy available. A company proposing to issue the red herring prospectus shall file it with register at least 3 days prior to the opening of this. This is a previous year question that's come in your exam. It's a previous year question. So, a company proposing the red herring prospectus shall file with registrar. This is the true statement. Okay, this is the true statement. Now, the last topic is director. The management of the company is with the board of director elected by the member of a company. Maximum 1 person company, minimum 1, maximum 15. Private company, minimum 2, maximum 15. And for the public company, minimum 3, maximum 15 director is there. A company may appoint more than 15 directors after passing the special resolution. Every listed public company shall have at least 1/3 of the total number of directors as an independent director, and the central government may prescribe the minimum number of independent directors in the case of any class of public company. C class. Important point. Done? Now, the methodology to be adopted for appointment of director and the rules for retirement of director is also discussed. In this, the director should hold the qualification shares. Maximum number of directorship, that is one director at a time, become 20 director of a company, but for public, that is 10. Okay, so this is written now. Question and answer. The maximum number of director in a private company, we have already done 15. Maximum in 15, public 15. Maximum in a public minimum, that is 3. Minimum in private 2. At least dash to number of director of public company by whose office is liable to determine the retirement by rotation, that is 2 by 3rd. C class. Done? Now, every public company, private company which is subsidiary of public having a paid up share capital rupees, that is nil. No need to require. Additional director is appointed by board of director. Alternate director, board of director. Casual vacancy is filled by the board of directors. So in every case, you can see here, we have a board of directors. That's it. Okay, class. So this is all for today's session, and I hope so you people like this session. And guys, we have this telegram. You can please scan this telegram and you can just ask your doubt 24/7 by this session. Okay, so thank you so much for attending the session, and right now the heavy discount is going on. Apply the coupon code Y391 for the maximum discount. Thank you so much.